Hello and welcome back to Inside the Contract. We are still on season 2. This is episode number 5. Today we dive into one of the most strategically important and often misunderstood features of the FIDIC 2017, the Dispute Avoidance and Adjudication Board, or DAAB. The DAABs or DAABs are not merely arbiters who step in at the end of the project. In FIDIC 2017, the DAAB is designed as an in-project mechanism to help avoid disputes and, when needed, adjudicate them. They function as a safety valve, ensuring disagreements don't stagnate and the project keeps moving forward. Understanding how the DAABs work and how to use them proactively is essential for success on modern mega projects, at least in my opinion. Although I heard many practitioners, being cynical or skeptical of the role of a DAAB, I disagree. I believe if used efficiently, they can benefit the project greatly, especially on large, on mega projects. Okay. Construction disputes are notoriously damaging. They consume time, money, and relationships, and can derail entire projects. Historically, disputes escalated to arbitration or courts, by which time evidence had deteriorated, key personnel had moved on, cost had multiplied, project delivery had already suffered. FIDIC addresses this problem by embedding DAABs into the contract as a live in-project dispute resolution mechanism. The DAABs aim to, first, resolve disagreements at the moment they arise, keep evidence fresh and accurate, protect relationships between employer, engineer, and contractor, prevent disputes from festering into large claims, maintain project momentum even when issues escalate. In short, DAABs exist to solve today's problem today, not years later. Okay, the switch from the DAAB to DAAB. FIDIC 1999 relied on the DAAB, the Dispute Adjudication Board, a body that reacted only after disputes were formally declared. FIDIC 2017 makes a deliberate shift into the DAAB, Dispute Avoidance and Adjudication Board, emphasizing prevention as much as resolution. A DAAB under the 2017 books can do the following. They can provide informal advice, can participate in meetings, can help clarify misunderstandings before they transform into claims, and they should remain actively engaged throughout the project. This is a fundamental cultural change. The FIDIC 2017 encourages earlier engagement with the board to help prevent issues escalating into formal disputes. The role evolves from judge of disputes to partner in dispute avoidance. Okay. Under 2017 red and yellow books, the standing DAAB is the default, appointed at the very beginning of the project and remaining active throughout. The standing DAAB is appointed within 28 days. FIDIC 2017 generally requires early appointment. I said commonly 28 days, within 28 days of the commencement date, unless amended in the particular conditions. Okay? Meets regularly, receives project updates, understands the technical and contractual context continuously, provides early informal intervention when issues emerge. This continuity builds credibility and speeds up decisions. Ad hoc DAAB, formed only after a dispute arises, lacks background knowledge, slower startup time, less effective in prevention, more costly due to late engagement. FIDIC 2017 aligns global best practice by pushing strongly toward standing DAABs, especially on complex, high-value projects. All right? Clause 21.1 rather sets out the detailed requirements for establishing the DAAB. Key components include appointment within 28 days from the commencement date, unless stated otherwise, as I mentioned above. Board consisting of 1 or 3 members, agreed jointly. Fallback mechanism using FIDIC nomination procedures. Contractual definition of duties, fees, and independence. Timely formation is essential. A DAAB appointed late weakens the entire dispute resolution chain because the board misses early context, parties lose the preventative benefit, claims may become stale or unresolvable. Late appointment can undermine the dispute resolution process and may itself become a contractual issue. Okay? When a formal dispute is referred, clause 21.3 establishes a clear, rapid adjudication process. The DAAB must review all submissions, conduct hearings as needed, ask questions or request additional evidence, issue a reasoned decision within 84 days. The decision is immediately binding, meaning work must continue according to the decision, temporarily final, unless challenged within 28 days, designed to prevent project paralysis. Okay? The decision is binding immediately, and the parties must comply while any challenge procedure runs. Okay? If a party disagrees with the DAAB decision, the contract provides a structured challenge procedure. 28-day window for challenge. A notice of dissatisfaction must be issued within 28 days. Missing this window means the decision becomes final and binding, even if flawed. Okay, so keep this in mind. Why is this important? Parties must act fast. Silence equals acceptance. DAAB decisions can quickly become enforceable outcomes. This is one of the most common procedural pitfalls. Contractors and employers who fail to issue the notice of dissatisfaction in time lose the ability to escalate permanently. If the DAAB decision or the DAAB decision is challenged, parties must enter a mandatory 28-day amicable settlement period. Goals of this stage is encourage negotiation, preserve commercial relationships, avoid escalation unless truly unavoidable. Only after this 28-day negotiation window can a party proceed to arbitration, the final step, in the FIDIC dispute ladder. FIDIC is structured to encourage escalation in stages: avoidance, adjudication, amicable settlement, and then arbitration. Of course, all of this subject to your particular contract and the applicable law. Okay? Okay, so if we look at a real-world insight, on some major projects, the DAAB appointment is delayed until after disputes have already escalated, at which point the avoidance value is largely lost and parties drift toward arbitration. By contrast, projects that appoint a standing board early on often resolve issues faster because the board understands the background and can intervene before positions harden. All right? So if we look at the common pitfalls, despite the value of the DAABs, many project teams misuse or underuse them. Frequent mistakes include, as I mentioned above, delayed formation of the DAAB, treating the board as a threat, not an asset, ignoring the DAAB decisions and hoping for reversal, failing to provide the DAAB with full transparent evidence, allowing procedural deadlines to lapse, not engaging the DAAB early in conflict situations. Okay, these pitfalls can cost contractors both time and entitlement. So let's take a look at some practical, takeaways. To maximize the benefits of the DAAB and use and stay compliant with FIDIC 2017, first, advocate for a standing DAAB, especially for complex design-heavy yellow book projects. Keep the DAAB engaged. Regular updates, meetings, and early warning discussions reduce disputes. Act on deadlines. The 84-day decision window and the 28-day challenge window are critical. Respect DAAB decisions. They may become final, sometimes unexpectedly, if challenge date, for example. Use the DAAB proactively, not just for formal disputes, but for clarifications and early interventions. The DAAB works best when it is seen as a project partner, not a final stage referee. Okay? So, to close, DAABs are one of the most effective mechanisms in the FIDIC framework, in my opinion, but only when used correctly. They offer speed, expertise, and continuity that neither arbitration nor court can match. As projects in the region grow larger and more complex, DAABs will continue to play a central role in managing risk and maintaining progress. Okay, and again, as I said, I've heard some practitioners being cynical or skeptical about the DAABs, but in my opinion, on large, complex projects, appointing a DAAB at the start of the project can be very efficient and can avoid many disputes and issues on the project. And again, this is just in my humble opinion. Maybe going forward, we can just all advocate for cultural change when it comes to the DAABs and how to use them correctly. Okay. Anyway, by this we come to the close of the conclusion of episode number 5. I thank you for watching. In the next episode, we will dive deeper into the enforceability of the DAAB decisions. Are they really binding? What if a party refuses to comply? How do arbitral tribunals treat them? These questions are critical for any contract practitioner. Again, thank you for watching, and I will see you next time.